Friends, in the formation of contracts, one of the concerns that the legislators had is the wielding of undue influence by a party who has a dominant influence on the other. Therefore, the section defines this in three parts. Used by one party to the contract of his dominant position. What is the purpose? The purpose is to obtain unfair advantage. Similarly, there may be various situations in which one party in a contract can be said to dominate the will of another. I am sure you have known of such cases, you have experienced such cases, and if not experienced, you must have been an observer to some situations. Third one is a rebuttable presumption, where a contract takes place between parties and transaction is unconscionable. What is that? Now, however, there are exceptions. Relationship between a guardian and his ward, father and son, patient and medical advisor, solicitor and client, they fall into subsection 1, where I have said party to the contract using his dominant position for obtaining unfair advantage. We as lawyers might sometimes exploit the weak position of the client by using our dominant position. And he may be vulnerable and might accept what we even dictate for our advantage to obtain unfair advantage. It may be his properties, it may be some such situation, maybe his house or the land or something. And similarly, a ward and a guardian. Guardian, though, has a big responsibility not to exploit his ward, but it sometimes may occur that he uses his dominant position and wants to obtain some unfair advantage. Now, it's very strange, father and son. Sometimes even father might exercise this. He may be a natural father or a stepfather. Medical advisors, of course, have been seen to exploit the position of the patients. Friends, I will just like to mention the case of Subhash Chandra Museb versus Ganga Prasad Museb, which is a case of Supreme Court. And Supreme Court decided this case in 1967. And they said such influence, however, must be undue with the purpose of obtaining unfair advantage. Not only the defendant has a dominant position, but he must use it also. That's why I said use it to obtain the undue or unfair advantage. Calcutta High Court said it doesn't matter if you have a dominant position, but the burden will be on the other side to prove that you used that dominant position to obtain the advantage. Now, there were unfair advantage is used as the meaning an advantage obtained by unrighteous means. What is that unrighteous means? Unrighteous means unfair, obtaining all sorts of underhand dealings to obtain, either by speaking lies or by coaxing or by persuading or whatever. Where it is in favor of the influencer and unfair to the other. That says it all. The test will be the transaction should have been in favor of the influencer and it should have been unfair to the person who gave the advantage. This has been beautifully described in the case of Pusat Rai versus Kannappa Chettiar, decided by Privy Council in the year 1920. Citation is All India Reporter, 1920, Privy Council 65. Related to Section 111 of the Evidence Act, and Section 111 of the Evidence Act has to be read along with the provisions of the Contract Act. This is the ratio of the case called Daya Shankar versus Bachchi, decided in 1982 by Allahabad High Court. What is it? Under Section 111 of the Evidence Act, mere fact of one party to the transaction being in a position of active confidence shifts the burden of proving good faith to the party who is in that position. Good faith is the burden of the party against whom it is alleged that he has used his dominant position. Under the Contract Act, again, what we said a moment ago, the contract or the transaction should appear to be unconscionable. Friends, a deed of settlement by a widow in favor of defendant was set aside for undue influence, where deed was executed and the means she had no independent advice. Now, court has gone to the extent that where the widow had no independent advice, even that deed was set aside. I was recently defending personally, I was defending the case of a daughter where a widow whose only son died, and within 14 days of the death of the only son, who was about 50 years old, the son was 50 years old, the lady was 80 years old, and the grandson persuaded the lady to execute a power of attorney in his name, power of attorney in his name, to authorize him to sell the only residential house in which the widow was living, the grandmother. The power of attorney was registered. The old lady, 81 years old, grandmother, went with him and to the registration office, registered the power of attorney. 6 months later, the grandson sold the property and took away all the proceeds of the property. The court definitely recognized it as a case where influence was used in an unfair manner, and it was also seen that it was in favor of the influencer. Let's go further. The contracts which contain terms which are unfair and unreasonable and shock the conscience of the court and are opposed to public policy, this was also a unconscionable bargain. Friends, we could go on discussing several cases under undue influence, but examples are many. And for example, we could talk of subsection 2, subsection 3. We could talk of, many such positions. But you have to understand that every transaction must, in order to put it to a strict proof, must be related to Section 111 of the Evidence Act, so that the burden of proof is on the person who has obtained the advantage. Let's move on to Section 17, which is a section which deals with fraud. Now, this section defines fraud and lists such act or acts which amount to fraud. For example, false assertion, active concealment, promise without intention to perform, any other deceptive act, or any act declared as fraudulent. Now, such acts should have been done by the party to the contract, or his agent, or other person with his connivance, but the intent should be to deceive the other party or his agent. So therefore, we are seeing this. One is intention and other is the word deceive. Intent to deceive is the key to understanding the word fraud. In the case of Kamal Kant Paliwal versus Prakash Devi Paliwal, a case of 1972, where it was held mere silence would not amount to fraud unless the circumstances of the case show that there was a duty to speak, or that the silence in itself is equivalent to speech, where somebody is under a burden to say what is being told is not true, but he keeps silent, then it amounts to speech. A mere false statement. Now, this is very interesting. A mere false statement is not fraud. If the party alleging fraud had the facts before it or had the means to know them, it could not be said that he was the defendant, even if a false statement has been made. What is it? Sometimes, if it is told to me that my brother has sold his house and has sold the joint house, or family house, and I have a means, somebody has spoken a lie to me, let's say. Now, I have means to know whether the sale has occurred or not, and I can verify it. This mere speaking of a lie would not amount to fraud. Friends, in the case of R.C. Thakkar versus Gujarat Housing, a case of 1973 decided by Gujarat High Court, the court clarified the foundation of the vice of fraud contemplated by Section 17 is that a man making a representation, with what intent? The intent is that another person should act upon it and must be taken to warrant his belief in its truth. Just examine this, what Gujarat High Court is saying. It says, fraud, vice of fraud contemplated by Section 17. What is it? Man making a representation, which he intends another to act upon. When a representation is made to somebody, the purpose is, or the intention is, that he should act upon that representation. And it must be taken to warrant his belief in its truth. Why would he act upon? Because he will say, he will believe this to be true. Now, this is fraud. Fraud as a cause of recession of contracts is generally reducible to fraudulent misrepresentation. When a contract is rescinded, then the cause or the cause of rescission is amounts to or is reducible to fraudulent misrepresentation. It is linkable, it is linked to a fraudulent misrepresentation. That is why the contract is rescinded. Accordingly, misrepresentation is either fraudulent or not fraudulent. So there could be two categories of misrepresentation. One is that it is fraudulent, another is that it is not fraudulent. If the fraudulent is the cause of rescission, rescission may take place under certain conditions as per Section 18. Now let's see what is misrepresentation under Section 18. Misrepresentation falls into the following three categories. One, a statement of fact which is false. Any breach of duty to gain an advantage to the person committing it by misleading another to his prejudice, but there being no intention to deceive. That is also misrepresentation. Causing a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. That is also a misrepresentation. For example, there is a case, famous case of Esso Petroleum Company, which used its expert knowledge and induced a dealer to take a petrol pump on lease. What was the expert knowledge? It overstated the amount of sale that the petrol pump will do. And it knew that what it is stating is not true. It was overstating the fact of the sale. The estimate of prospective sale from the station was exaggerated. And dealer was awarded damages for breach of warranty. This is a case which is decided by Privy Council in 1976. Again, in another case, Bliss versus Wilkinson, which is an appeal case of 1927, it was held contractual terms must be distinguished from words of expectation or estimate which do not form part of the contract. Friends, let me emphasize this. The terms of the contract must be distinguished from the words of expectation or estimate which do not form part of the contract. When a contract is written, the language is different and the expectation or the estimate is different. Therefore, there must be a distinction drawn from the words of expectation when a contract is reduced to writing. Terms are reduced to writing. Terms must be distinguished from words of expectation or estimate which do not form parts of the contract. And statements made honestly may not give rise to liability. Now, if you have stated the fact, for example, if in Esso Petroleum, the company had truly stated the amount of sale that the dealer can expect, then the company would not have been made liable for damages. Now, what is the effect of the agreements where there is no free consent? We are now coming back to the spirit of Section 10. If consent is caused by coercion, like there we said, what is, there should be free consent. But we did not say what is the effect if the consent is caused by extraneous elements. What is that extraneous element? A person may give his consent, but there may be coercion behind it. It may be based on fraud, or it may be based on misrepresentation. Then the contract is voidable at the option of the party who has been so led into giving the consent. Or if he thinks fit, he may insist that the contract shall be performed and he shall be put in the position in which he would be had the representation been true. This is his option now. He can call the contract void and he can avoid the contract. But if he so thinks, he may insist, if he so likes, he may insist that let the contract be performed, but he should be put in a position where he would be had the representation been true. Based on which representation? the representation of based believing which representation he gave his consent. Now, please, when you read section 9, friends, refer to 5 illustrations in the statute book, because the framers of the Contract Act have clearly given 5 illustrations in this section provided as part of the statute. Therefore, this section states the legal effect of coercion, fraud, misrepresentation in rendering contracts procured by them voidable. Earlier sections have let down their definition. Voidable. Now, I suggest we continue this in our next lecture. Thank you.